And that brings us to some of these cases that you argued.
Yeah.
The first one that you wanted to talk about was Bedell v. Davis at 202 Fed 2nd 1. That's a 1953 case.
Yeah. Well, let me fill you a little bit in the background. I was able to, as I say, I had one child first, and then of course I had my second daughter. But our law office was about 10 minutes. I was probably driving 5 minutes from the house. Also, my husband, we lived with my husband's mother because she was a widow and had nobody but my husband. So we always had a babysitter. And I really wanted to enjoy my kids when they were young. And so in the beginning, I did, for example, a lot of the briefs. I would write all the briefs for the office and maybe requests for instructions and all of those things because I could do them on my own time. And so I did write a lot of the briefs. But getting back to that Bedell case, that was a case that I argued while I was still practicing in Boston. That was
1953.
1953. Yes. And I argued that case in the Boston, it was in the Circuit Court of Appeals in Boston. And I argued it because my husband had a sore throat or laryngitis or something, and really fairly close to the time of argument, he couldn't do it. So I had to fill in, and you know, I hadn't written the brief, so I wasn't all that much familiar with the case. But anyway, I just remembered that I was kind of terrified because I don't think hardly any women argued, and there was hardly any women lawyers anyway, but not very many of them argued in the Circuit Court of Appeals. And the judge, Magruder, who was the chief judge of the court, I don't think took too kindly maybe to women because I couldn't get 3 words out that he didn't have questions. So my argument was completely, you know, sort of thrown out of whack by all the questions that he asked. And it really was interesting. It was a case, here again, the small case, where somebody fell into a grease pit. Remember in the old days, every service station, they had these grease pits. And this woman went to get her car, something done, and she got out of the car and she slipped on some oil or something, and she fell into the grease pit. But they said, no, that was she shouldn't have got near there, and that was contributory negligence as a matter of law. And his name Magruder felt so strongly that she shouldn't have gotten a verdict in the lower court that he wrote a concurring opinion that she was only a gratuitous licensee. She shouldn't even have been near the grease pit, and she parked her car quite close to it, and she was. It seemed to me it was a very wrong decision, but however, that was the first case, and I lost that one.
So that turned on an issue of contributory negligence.
Yeah, in those days you didn't have comparative negligence. It's either for contributory negligence, and they had gotten a verdict in the lower court, which of course then they lost.
Your firm had gotten that verdict.